Supplementary rest for pronouncement of judgment, item number 1.
So, Mr. Sinkon, I have to disappoint you.
Yes.
See, I'm bound to follow the decision of this court as far as the maintainability is concerned. Once that is decided, the other just follow suit. You see, there'll be a lot of loopholes for you to plug. I'll read out only the operative portion. Again, as observed above, the petitioners, as far as the case of transfer is concerned, has made out a case for the impugned transfer order to be set aside and quashed, which is done so herein. The interim order dated 19/5/2017 is hereby made absolute. Only relevant authorities cited by the parties have been taken into account, the question raised in this petition being adequately answered. This petition accordingly disposed, no cause.
Highly applied.
Thank you.
It was the 217 WPC regarding that amalgamation.
No, this, sorry. I have decided, I mean, it's a common judgment because you see, it interlinks.
Yes.
And that 217, I have found out there is, you see, the procedure has not been followed. Procedure has not been followed completely. You read section 12 and you will find.
My lord.
So, underground, that amalgamation has been set aside. And once the amalgamation has been, declared null and void, the transfer will not stand because that was,
subsequent to
that.
Obliged.
Thank you.
Any mention?
Please, Lordship. Lordship, I beg to mention item number 18.
You are for?
I'm the petitioner.
On premier by the petitioner. How long?
1 week.
Latest matter to 2 weeks.
Obliged.
Supplementary item number 2.
May I please, Your Lordship? Lordship, I beg to
When
mention.
you have to mention, no, be fast.
Yes, Your Lordship.
Otherwise, you're taking your time. Sometimes you
My
don't know actually
apologies, Your Lordship.
taking a walk or something.
Your Lordship, I beg to mention item number 9 of the hearing list, Your Lordship. Your Lordship, I have just received instruction to appear on behalf of respondent number 8, 9, 10, 12, 13, 14 and 15. Your Lordship, I'm yet to file my wakalat as well. So I seek some more time, Your Lordship. At least 2 weeks, Your Lordship.
The 2017 matter.
I've just received instructions, Your Lordship.
Your Lordship, I haven't received a copy of the affidavit
Affidavit?
with regard to the RTI inquiry from the petitioner.
Lordship, this is a long pending matter.
Long many matter, no doubt.
Very long, so 7 years now. Now he is entering appearance on.
On behalf of respondent 8, 9, 10, 12, 13 and 13, 14 and 15.
You are here in this case, Mr.
Yes, Lordship. For two private respondents.
Oh, you also for respondents?
For the petitioner, Your Lordship.
So, fine, we'll take it up next week then.
Yes, at least 2 weeks, Your Lordship.
8 weeks.
I'll try to seek because I haven't received my brief also for that reason.
On pre-made by the parties, latest matter 2 weeks. Be sure,
Yes, sir.
be sure. Next date, no more.
Definitely.
No more conversation.
Obliged.
Thank you.
May I please, Your Lordship? Lordship, I beg to mention item number 16. On behalf of Sir E. Khan. I'm appearing on behalf of respondent number 2, Your Lordship.
on pre-made by the petitioner, not objected to by respondents. This is matter after 2 weeks.
Much obliged. Your Lordship, I beg to mention item 10 and 11, Your Lordship. I humbly pray this matter may be taken up after 2 weeks, Your Lordship. 10 and 11.
10 and 11. I have no objections, Your Lordship.
You are for?
Respondent number 6, Your Lordship.
For respondent.
For the petition, Your Lordship.
It's also 2020 matter. So how long?
2 weeks, Your Lordship.
2 weeks. What is this matter about?
Suspension, Your Lordship.
Suspension.
Yes, Lordship.
You are still under suspension.
Yes, Lordship.
It is not a case of suspension, Your Lordship.
Oh, that.
Yes, Your Lordship. So far as state is concerned, it is a case of a voluntary abandonment of service.
School matter.
Yes.
We'll take it after a week.
Your Lordship.
On prey made by the respondent.
Number 6, Your Lordship.
Number 6, seeking accommodation on the ground that and seem not being objected to by the petitioner. Matter is adjourned. This is matter after 1 week.
Much
Your Lordship.
So 10 and 11.
Please, Lordship. Lordship, I beg to make mention for item 12, Lordship. 12 and 13.
So 12 and 13.
Yes, Lordship, they are similar matter, Lordship.
What is the subject matter?
Lordship, this is regularization, Lordship. Teaching.
Regularization.
Yes, Lordship.
On prey made by the petitioner. This is matter after 2 weeks.
Lordship, similar prayer for item 17.
In this way, what is left now?
Lordship, we have taken steps with regard to the respondent 3 and 4. But
Who's 3 and 4?
3 and 4, they are
Private respondents.
private respondent, Lordship.
Private respondent.
Yes, Lordship.
This is the human rights.
Yes, Lordship.
Lordship, if this matter may come up in the board, Lordship. If this matter can come up in the board because they have to take steps, they've also taken steps already. And this matter is fixed for hearing for the longest time, Lordship.
Yes, I've taken steps.
You are yet to take steps.
Yes, Lordship. Nobody taken steps, but it's not yet delivered.
So then why are you mentioning it? If you are supposed to do something, you have to wait to your turn. That matter we call up. Then you make a submission. This is the stage only, for seeking of accommodation, adjournment, on personal grounds or otherwise. As far as as far as steps to be taken, steps has been taken. These things will come in due course.
My praise, Lordship, because Mr. Policy is not in.
Doesn't matter. You are there. You're competent enough.
That means service is yet to be completed.
Exactly, but that should not be. See, we should not. The court should not encourage the matter to be heard at this stage. That's what let some propriety be maintained. We'll take it up. Let it be called up.
Okay. You're obliged.
Please, Your Lordship. Your Lordship, I beg to mention item number 14, Your Lordship. Some personal difficulty, Your Lordship, if this matter can be taken up after 2 weeks, Your Lordship.
You are for?
Petitioner, Your Lordship.
It will be after 3 weeks, Your Lordship.
Why? What's the matter about?
This is regarding a regularization, Your Lordship. In fact, Your Lordship, in a similar matter also, those will be the prayer for regularization had been turned down, Your Lordship. When the matter reached up to the Supreme Court also.
Okay. So it's a There's a covered
Those
case.
MTET teacher, if your lordship are kindly recall those teacher who have not qualified, who don't have that qualification.
MTET.
So far, the picture is concerned, it's a stopgap arrangement only, your lordship.
I will hear the matter. 2 weeks. On pre-bid by the petitioner, this is matter of 2 weeks.
Highly obliged.
Supplementary list item number 2.
Yes, Mr.
I have submitted my
You have submitted.
some books, man.
And yes, Miss Silla.
Lordship, yes. May I submit the relevant?
Yeah, please do. Thank you.
Anyway, over about the list which I've given a the hard copy also, madam. I've given the list, madam. Some of them are
Fine. What? What should do this bad? I'll go through this.
Lordship.
My lord, as far as Tufan Singh is concerned, my lord, I have given the on the list of books only, my lord. This is 2021 for SEC 1.
You have cited all the
My lord,
relevant
my lord.
paragraphs.
Lordship, and as your lordship had, it's fallen from your lordship's mouth that on section 37, lordship, we've produced the relevant citation, lordship.
Fine. So I'll go through these papers and
My lord.
I'll pass the orders.
Obliged.
Much obliged, lordship.
Thank you.
Supplementary list item number 3.
2,
3, 4.
2, 3, 4, 5, my lord.
Same order.
Lordship, I'm sorry, lordship, this is the marked copy. There are 3 sets actually. I've given you the unmarked copy, my lord.
It's new. You don't have the regular court master.
Lordship.
My lord, 2021 for SEC 1, my lord, the 11th paragraph, I'll give it to the court master, my lord.
Please do.
Much obliged, lordship.
From the main list item number 1.
May it please your lordship, in this matter, we are supposed to file counter affidavit on behalf of respondent to your lordship. I pray that if your lordship can kindly grant us 3 weeks time.
This matter has been lingering only on this point. All the other respondents are filed?
Yes, lordship. Other respondents, I have also find my counter, or means rejoinder, and now only the respondent number 2, because respondent number 2 has very belatedly entered appearance.
Letter counsel for the respondent number 2 has submitted that the counter affidavit could not be filed today and has sought for some more time for the same to be filed. The prayer not be objected to by the letter counsel for the petitioner. The same is allowed. Let the said counter affidavit be filed within the next date fix. How long?
3 weeks, your lordship.
This is matter of 3 weeks.
Much obliged.
Item number 2.
Number 2, no?
Your lordship, Mrs. Dabnat is on another court.
What is the
Lordship, my instruction is that the compounding has been filed and it's awaiting necessary orders now.
no, last time it was the ROC who was yet to join,
Yes.
and he is
Now he has joined and we have already moved. Now it's pending for orders. Because compounding, we have to pay some money. So the moment the money is deposited, then necessary orders will pass.
So how long?
2
How long will
weeks,
it take?
Lordship. 2 weeks.
2 weeks. Mr. Pinambri, counsel for the petitioner, has submitted that the matter of whereby the issue of compounding of the relevant offences, which is before the ROC, Registrar of Companies, has been taken up, and what remains is for the petitioner to deposit certain sum of money towards the same. For this, after which the ROC would then pass the final order. In this regard, the learned counsel has submitted that some more time may be allowed for the formalities to be completed and necessary report to be filed for this court. Anything?
I have taken instruction from the department, madam. As far as Manipur State Power Company and Distribution Company, both the cases, of course, they have filed the custody report, but they have filed in the year 2017, my lord, and the due date is September 2015, my lord. So there is a delay in filing, my lord, and further they have to approach the compounding of this matter.
That's what they have done, I believe.
No, this is regard only MECL. But what my friend has submitted is with the item number 6 and 7.
Okay.
In that matter, Lordship, the cost audit report was filed on time. I have my instruction that it was filed on time, since the allegations now is that it's for the financial year 14-15. So I have some letters which I've already submitted to them.
My lord, the cost audit report was filed on 26th June 2017, my lord. Whereas the due date for filing 14-15, financial year 14-15 is September 2015, my lord. 27th September 2015 is the due date. Whereas they have filed on 26th June 2017, my lord. It's almost 2 years delay.
Which one you got?
26.
No. 15. 4/3/2015 we filed. It was within time, these two cases.
Lord, the due date is September 2015, not 17, my lord.
Yes, he's saying so.
Every data
keep-
has to be filed.
I don't know what he is reading, Your
He
Lordship.
keeps saying 15, you say 17.
My copy is that, Your Lordship.
You have the records with you, Mr.
Yes, yes.
Yes, they have.
Just show a copy to Mr.
Which one you got?
This is one. 16.
This is. Wait now.
Sure.
21 April.
Yes.
21 April. This is what? State Power.
Manipur State Power Company.
29/10/2016.
Yes, but still there is a delay, my lord. If it is 16 also, still there is a delay, my
This
lord.
is 4/3/2015. It is within time, Your Lordship. I'll take instructions again
one
because
thing,
we have filed the cost
My
audit
lord,
on
I
time.
got instruction from the department.
You do one thing, you sort it out.
We'll sort it out.
Sort it out and see. If there is any concession that can be given here and there, as far as delay is concerned.
My lord, I inquired from ROC what can be done. They said that there is, of course, they have filed it, but then there is a delay in filing. So for that, this prosecution was filed. So
Anyway, if
Only thing they can do is just file one
because they have
compounding petition.
From what I can understand, they have filed the application for compounding. So that is before the ROC.
That is with regard to MECL.
Not these two matters.
What about the other two then?
These two, because we've already filed a cause audit report on time. Because now, after we filed, in short, I'll explain, Your Lordship. They have filed a complaint before the trial court, making an allegation that cause audit report was not filed for the year 13-14. So, since 13-14, section 148 of the cause audit report was not implemented at that point of time, it was not enforced, so that is why we before Your Lordship. Now, when the matter was heard several times, then they made a submission before this court saying that there's a mistake. It should be 14-15. Now, if the statement is that it's 14-15, because from 14-15, the 148 has been enforced. So accordingly, we have filed the cause audit report on time. So now the only left is that if my learned friend says that there's a slight delay in filing the cause audit report, that is his instruction, there was a delay. And I'll take instruction also whether there was any delay also.
My lord, if we go by the paper which they have submitted before this honorable court,
I'll give the entire data, Your Lordship.
29th of October 2016, they have filed it. But whereas the financial year 14-15, the due date is September 2015, my lord. Of course, the period is 31st March 2015, but due date is September 2015, 27th September 2015.
We'll try to understand that the matter before this court is for financial year 13-14. 14-15, if they're saying that is for them to take steps, that is for me to take steps. It's not an issue before this court.
Okay. If that is not the issue before this court, then why?
Then why he wants to drag the financial...
My lord, as far as the rectification of this petition in the trial court is concerned, my lord, there was a hearing in that regard, my lord. And we have filed our petition also in that regard, stating that this is not
there was a mistake
typographical error, my lord. Okay. And this is not 31st.
So you insisted on 14-15.
Yes, it is 14-15, financial year 14-15.
But he says it's 13-14.
In fact, my lord, while filing the petition in the trial court, we have categorically mentioned that it is financial year 14-15, but due to typographical error, it is 31st March 2015 we should have written, but we have written 31st March 2014. That was the only error we have committed there.
But that is a grave error, Your Lordship, in a criminal case, because cognizance is taken on the basis of the year which they have stated. Now, this is not a civil proceedings where they'll go and file an amendment, and cognizance has been taken, summons has been issued to the parties to appear.
What you have to do is you have to start a fresh proceeding.
Now they have to withdraw that complaint.
As far as 13-14 is concerned, but if we go by 14-15, then compliance has been
yes.
13-14 they have filed their return.
13-14 because the law was not enforced, Your Lordship. Okay. That is why we before Your Lordship.
In fact, my lord,
because that amendment has come
came later. Then from 14-15 we've started filing the cause audit report.
In fact, my lord,
but that issue should not be before this court. It's for them to take steps whether there's a delay or not. File a fresh case before the trial court.
If your lordship come to their petition, my lord, that is annexure 7, if I'm not wrong, where categorically mentioned this matter is pertaining to financial year 14-15, my lord.
Your lordship will not confuse the annexures and the pleadings.
The annexure itself speaks, my lord.
The annexure says maybe 14-15, but the pleadings whereby the trial court had taken cognizance is on the basis of the complaint. Now, if there's a mistake in the complaint, they should take steps before the trial court.
In their criminal petition, my lord.
No, what we do then, if you insist, then we will hear those petition. We will hear the matter.
My lord.
As far as those two matters are concerned with regard to the Manipur.
Yes, Manipur and Amrit Cements.
My lord. My lord.
So then we'll hear. And as far as the other petitions are concerned.
They are the PS, thank you, that they have filed compounding.
So we'll do that, Mr. Deb.
My lord.
Then you can make out your case. You see, whether
my lord, I inquired from ROC.
Yeah, whether you have a case or not.
Because, Lordship, they have filed an affidavit before this court saying that there's a mistake also.
Yes, my lord.
And the proceedings have been stayed. I don't understand how they file an application when a matter has already been stayed.
we have not filed any petition before the trial court, my lord.
That is why, no, they have to go to the trial court. Why come
When
before
there
this
is a
court?
stay, how can we
Those
file
are-
petition, my lord?
Those are, again, procedural matter. Let's see.
My lord.
They have admitted there's a mistake before this court.
Yes,
Yes,
that's what
accordingly,
this
we
is.
have filed a petition, my lord, to allow us to rectify the
So
defect,
what is
my
to be
lord.
done in such a situation?
Whether this court will allow your lordship to rectify before this court.
As far as the typographical error is concerned, there was a hearing in that regard, my lord. And our prayer was that we may be allowed to rectify the defect, my lord.
But
That is his liberty before the trial court.
because the
My lord, when
complaint,
there is a stay
Yes,
in the trial court, how can you file any amendment petition, my lord?
exactly.
Just now he said we file a rectification. There was a
No,
hearing.
the petition was filed before this trial court.
Before this court or trial
So
court?
we will see. This court will examine. The court will examine the issue. Court will examine the issue
My lord,
as to what is, what can be done.
my lord.
Whether you are entitled to file an application for rectification before this court, or you have to
Go to the trial court.
in the event that the proceedings in the trial before the trial court are stayed.
On the month of
What
February
is to be done in such a situation? What is to be done? So you have to find a way out for this court to pass necessary orders.
My lord,
That is only the procedural aspect.
my lord.
As far as merits is concerned, if you wish to proceed with the hearing, we will do it.
Because in my humble submission, the matter is very simple. In fact, the matter can be closed.
But it cannot be called. My learned senior is stating that this is filed on time, my lord. As per the Companies
My
Act.
lord, if he is disputing this, 14,
Yes, I am
50,
disputing that, my lord.
he has to be disputed before the trial court.
Because this record was brought before this honorable court, my lord. It is not brought before the trial court. my lord.
Exactly. So we'll see as to what is the role of this court as far as the matter is concerned. Perhaps the petitioner can withdraw the petition here, and matter can be sent back to the trial court for for fresh agitation. That can be done.
My lord.
Your lordship, I'll have to take steps. I'll have to find out whether it's on time or not, because he said there's a delay. So I'll have to speak to my client saying whether there was any delay in filing these course audit reports.
Fine.
Item number 3.
3, 4,
2, 3, 4, 5, that is
2, 3, 4.
and 5, 6, 7.
6 and 7 I am appearing, my lord. And 2 to
5, 6, 5 is Amrit Siman,
Amrit Siman.
6 is Manipur,
7 is Manipur again.
7 is Manipur. So
Let it come together, Your Lordship, after 2 weeks. By then, I'll take all necessary steps.
my lord.
Akiniga 5, 6, 7 ne? So on submission made by the parties, place this matter after 2 weeks. Yes, Mr. Devnath, order has been dictated. Your ROC is yet to pass the order. So you ensure that the ROC pass the order as far as the other case are concerned.
Obliged.
You seek instruction, and
My lord, I already got instruction. That's what they said.
so let him
I'll
verify that.
verify this, Your Lordship.
My lord. Highly blessed.
Obliged.
Item number 8.
This is that matter, my lord, where, my lord, the private respondent, my lord, by misleading the authorities, my lord, he had formed an ad hoc committee, and then, my lord, he had taken the power of draw and disbursement of salary, my lord, the salary grant. Thereafter, my lord, whatever grants he received, my lord, he has used it to his advantage by depriving the petitioners, my lord. For that matter, one of the petitioner did not receive any amount, any salary at that during his tenure, my lord. So thereafter, my lord, we approached this honorable court because we are not receiving salary. My lord, so, my lord, he was made a party, but he did not appear, my lord. Accordingly, an ex parte order was issued. So till date, he has not appeared. So the case is proceeded ex parte, my lord. Now, part of the relief has already been, our prayers were twofold, my lord. One is that during the tenure of the private respondent, whatever salaries which are due, which has been misutilized by him, should be refunded. That is one part of the prayer, my lord. Second was that, my lord, that the salary that are not being released to the petitioners should be released. So thereafter, my lord, the government was pleased to issue an order giving the petitioner number one because he was the head teacher. So, my lord, the state gave him the right to take the power of draw and disbursement authority. So thereafter, my lord, they are receiving the salaries. So as far as current salaries are concerned, that is not an issue, my lord. So, my lord, my prayer at this point from this honorable court is that if this honorable court directs the private respondent, my lord, to release whatever salary or whatever funds that he has misutilized or which he has taken, that should be given to us. That we are praying for this direction, my lord. Secondly, my lord, there is also a humble prayer. If the state can, this whatever current salary is from henceforth, my lord, if it can be directly credited to the accounts of the 4 teachers, my lord, for the petitioners here.
That would be that would be according to the prevailing practice.
My lord.
What is the practice? Whether it is credited directly?
As my lord, as far as SSA schools, I was told. Of course, this is not an SSA school, but as far as SSA schools are concerned, my lord, I was informed that these days the government is, my lord, crediting the salary directly to the account of the teachers.
Because the accounting system has been centralized.
My lord.
So we follow the same pattern almost everywhere, even with us also. So more often than not, it is credited to the account of the the employee.
Yes, my lord, because that way it becomes convenient also.
And what is followed in your case?
My lord, so far it is being released to the directly to the
managing committee.
Yes, my lord. But
and they will disburse.
No, yes, but at this point, my lord, at this point, it is being directly disbursed to the head teacher of the school, my lord, in the absence of the managing committee.
Okay.
So as and when managing committee is constituted, my lord, it will again go back to the managing committee.
Oh, because this is because of the school is a government-aided school.
Government-aided, ad hoc school, my lord. That is an ad hoc.
Because that grant and aid is, you see, only specific to the
salary, man.
School and
yes,
salary
grant
meant for salary.
Yes,
that you see, the court cannot unless until there's a system in place. As far as the accounting process is concerned, I don't think the court can direct that because those are matter of policies.
My lord. So, my lord, in that regard, of course, I can inquire, my lord, what is the prevailing custom, my lord, or procedure. Because if that can be permitted, well and fine. If that is not a procedure, then of course it's a different issue, my lord.
But like you said, the private respondent
has not appeared.
Has proceeded ex parte.
Yes, my lord.
So how can this court become an executing court then?
Well, this is a read court, my lord. Now this salary grant is also already given by the government, my lord. It's not a case because the grant is being given by the government. The government is involved. Grant has already gone somewhere. But does anyone have the right to misuse that fund, my lord, depriving the petitioners? Well, this is a good ground for a writ, my lord.
I think that will be in the realm of a criminal proceeding.
My lord, that may be there, but my lord, if there is a direction from the honorable court, that will, my lord.
If you or the management or whoever, or the government for that matter, is aggrieved by because that would, prima facie, it would amount to embezzlement or fraud on the part of the private respondent.
Could be, my lord. But my thing is that, my lord, if there is a direction from this honorable court, then, my lord, he'll be bound to refund that amount, my lord. And he is knowing fully well that he is guilty, that therefore he is not appeared before this honorable court.
You just narrate the facts to the.
My lord.
Please.
About the petitioners, there are 4 number of petitioners here in this writ petition.
Yes.
So in fact, my lord, they are the founder teachers of this, my lord, popular government aided UP school, Gandhimari, West Garo Hills district, my lord. Now, my lord, they were appointed, all of them were appointed in the year 1997, my lord. All the 4 teachers. The petitioner number 1 in 11/1/1997, 2 in petition number 2 in 20/1/1997, petition number 3 in 23/1/1997, and the 4th petitioner was appointed in 3/2/1997, my lord. Now, my lord, since then,
Yes.
they've been serving in the state school, my lord.
Yes.
So, my lord, the school started getting the government grant from the year 2000, my lord.
Yes.
So, initial, my lord, the grant was to
2000?
2000.
Year 2000.
In the year 2000, my lord. Because the school was founded in the year 1997, and thereafter, my lord, it became it started receiving grant from the year 2000. My lord, since then, these 4 teachers have been there, and they have been getting their salary grants, my lord. Initially, it was, my lord, 6,000 per month, and my lord, at the filing of the writ petition, my lord, during the period of filing of the writ petition, the grant amount was 66,000 per month for the salary of the teachers, my lord. So, my lord, what had happened, my lord?
Yes.
This Abdul Samad Sheikh, who is the private respondent, my lord.
His respondent number?
He is respondent number 7, my lord.
Yes.
Yes, my lord, he is private respondent number 7. And my lord, he was appointed as at a very later stage, my lord.
Appointed on?
My lord, he was appointed on my apologies, my lord. I'm afraid, my lord, I think his date of appointment is not mentioned, my lord. Yes, my lord, our initial...
if his seniority is a question,
my lord,
then you should have that
No, my lord, because there is this private respondent was a petitioner in the earlier round of litigation, my lord. He had approached this honorable court by way of a writ, my lord. That was, my lord, WBC number 357 of 2017, claiming that, my lord, he is one of the sanctioned teachers. And my lord, after at length hearing, all the parties, in fact my friend was the government counsel in that case also, my lord, the court came to a finding that he is not. So the question of he being sanctioned teacher is, so there all facts were placed before this honorable court, my lord, and this honorable court came to a finding that he is not a sanctioned teacher. And the court, that order is annexed, my lord. That order is at annexure 3 of the writ petition, my lord.
Page?
Annexure 3 will be page 41, my lord. My lord, in the order, of course, it's reflected, my lord, while he was appointed. If I read this, read the order, my lord.
Yes.
The petitioner before this honorable court was appointed as science teacher on 31st, that is his claim, my lord, which is not true. Science teacher on 31st December 2000 in the popular GAUP School, Gandhimari, West Garo Hills District, Meghalaya. The grievance of the petitioner as projected in the writ petition is that the respondents are not paying him the correct salary and that certain areas have accumulated, again false acquisitions, my lord, have accumulated which have not been made over to him. The petitioner also claims that he is a teacher teaching against a sanctioned post, again a false claim, my lord, entitled to against a sanctioned post entitled to higher pay. As such, prayer has been made, payment of salary at the enhanced rate and for release of the area's salary as payable against the sanctioned post. Ms. A. Sinha, learned counsel for the petitioner, submits that the petitioner was paid only 5,000 per month instead of 16,000. These are all false acquisitions, my lord. From January 2017 to May 2017. The latter, which is the salary payable to the sanctioned teacher, and as such, the petitioner is entitled to areas of salary amounting to rupees 55,000 for the said period. The second submission as advance is that the respondents should have paid the petitioner the full enhanced salary of 16,000 per month with effect from June 2017 till date, which learned counsel contends is the salary of a sanctioned teacher. The learned counsel argues that the claim has been made in view of the fact that the government of Meghalaya in the education department wide letter dated 19 June 2017 had approved for increasing the grant in aid to the 844 ad hoc primary schools. And as per this increase in aid, the salary of the head teacher and assistant teachers. So this is actually head teacher and assistant teacher is actually petitioner number 1 and the rest of the teachers, my lord. But how he projected the case, my lord. Head teacher and teachers and assistant teachers were enhanced to rupees 18,000 and rupees 16,000 respectively with effect from January 2017. As such, she prays that a mandamus be issued to direct the respondents, both state and private, to release the areas in salary and to pay the petitioner the enhanced salary. So, my lord, here Mr. H. Abraham, learned counsel for respondents number 1 to 5, submits that the claim of the petitioner is not supported by any official orders. And moreover, the norms as referred to by the petitioner relate only to SSA upper primary schools administered under the provisions of the Right to Education Act and not to ad hoc primary schools which are administered by the state government under the general norms. He further submits that the concerned school has not been put under improved system, but however the school follows the norms of 4 sanctioned teachers, so it's clear, my lord, and that the managing committees of such school maintain additional teachers from their own resources. So, my lord, he is an additional teacher. He also submits that petitioner not having been appointed against a sanctioned post, and moreover the salary is claimed not being as per the norms followed for such schools, there is no merit. There is no merit in the writ petition. So, my lord, there is already a finding as far as the position of the, my lord, private respondent is concerned. It's a clear finding, my lord. There is no merit in the writ petition and the same should be dismissed. Mr. H.L. Sangrashaw, learned counsel for the respondent, that is the managing committee, my lord, which was in existence at that point, submits that the school managing committee manages and runs the school by distributing the lump sum grant as received from the state government proportionally among the teachers in order of seniority and post they are holding. He also submits that the writ petitioner is well aware of the conditions of employment and entitlements that would accrue to him in the said post. As such, learned counsel submits the petitioner cannot at this stage make a claim for payment of salary which is unrealistic and not applicable to the said school, inasmuch the school is not receiving the improved grant in it. My lord, finally, my lord, I take to para 7, my lord. What is the finding? The last para, my lord. Yes. After hearing the learned counsels for the parties, especially the concessions made by the learned counsels for the petitioner, this writ petition is accordingly disposed with the direction that the petitioner be paid the salary as fixed by the managing committee by its various resolutions and stands currently at 9,020 regularly, and further that he be allowed to withdraw the arrears salary as due. So, my lord, this is the salary which is due to him. But what had happened, my lord? Thereafter, the petitioner did not agree to this. When he went back to the school, he did not agree. In fact, he circumvented this Honorable Court's order, formed an ad hoc committee, took over the charge of joint disbursement officer, and he used the fund according to his convenience, my lord, by depriving the petitioners who are rather forced to approach this Honorable Court, my lord. The situation was such that we had no other option. Prior to approaching this Honorable Court, we had also filed representations, my lord, with regard to the salary, that please, our salary grants are not being released to us as per requirement, as per notification. But then thereafter, my lord, so since we did not receive any reply, so we approached this Honorable Court, my lord. But however, during the pendency of the writ petition, my lord, the government had given us part of the relief. In fact, the joint disbursement authority has been given to the petitioner number 1, my lord. So thereafter, the salary grants are being, my lord, disbursed as per the usual norms, my lord.
So what is your prayer?
My lord, I had made several prayers, my lord. Now, my lord, as far as prayer number 1 is concerned, my lord, that actually has, my lord, more or less become infructuous, because with the passing of time, my lord. Now, prayer number 2, my lord, my prayer is at page 20.
Yes.
Prayer number 2 also, my lord, that is also fulfilled.
Because in the meantime, you have been given.
Yes, my lord.
Petitioner number 1 has been given the
yes, my lord.
DDO powers.
Yes, so that is also fulfilled, my lord. Now the third is, my lord, because he is the private respondent is also holding certain documents with him, my lord. Official documents.
When he was acting as DDO then.
Yes, my lord. So he is also holding certain official documents. So we prayed for a direction from this Honorable Court that he should hand over all the documents, relevant papers, with the management, etc. Whatever is there, maintain. Refund the money drawn in excess, misused. So any amount which he has drawn in excess or misused, so that he should refund, my lord. And of course, the fourth prayer is, my lord. Of course, this will, because joint disbursement.
Because now he is no longer DDO, so.
My lord, but what our prayer is that further be pleased to direct the private respondent number 7, Shri Abdul Samad Sheikh, to refund the actual salary of the petitioners as per government sanction. So this actually also comes within the other prayer, my lord, that whatever money he was holding. as per government sanction, which remains unpaid till 28/2/2021. So, my lord, the period was from the period is mentioned in the paragraph above, my lord. Disbursement officer with effect from 1/9/2019 to 28/2/2021. So this was the period, my lord, where he was withholding the money. So we are saying that whatever money it is with you, it is lying with you, you please hand it over. And of course the other prayer which I had made, my lord, that direct the state respondents to clear. So this is also, my lord, this is also cleared. Prayer 5 is also met, my lord. Prayer 6 is, my lord, and may direct the appropriate state authority and or school managing committee that the petitioners number 1 to 4 shall be given their salaries as per the government sanction. And so this is our, my lord, sixth prayer, my lord, that whatever sanction amount is there, you kindly give us that salary.
Yes, Mr. Ram, what do you have to say?
On my part, I have nothing to say because I think the grievances of the petitioner has been redressed on our part. But with regard to the managing committee and the private respondent, I think I will not be appropriate to answer those questions. Otherwise, if I'm pleased to go through the appointment letter, none of the teachers or none of the read petitioners are also been regularized as per the annexures. They have annexed as annexure in the writ petition, Your Lordship. So those parts, because this the
no, my lord, they have been regularized.
They have not enclosed the regularization letter, Your Lordship.
They have been regularized, my lord. There, that is why we have mentioned, my lord, their name is also there in the list of the teachers, my lord. We have mentioned in the paragraph.
The problem here is that the dynamic working of the managing committee will remain mystery, because now whoever is appointed as a managing committee, then I'll be the sole authority to appoint any teacher of my choice. Then when my term is over, then another managing committee will come again. Then another managing committee will appoint teacher of their choice. And the government, we sanction the money in lump sum.
But those, whatever action taken by the managing committee, as far as recommendation of teachers to be appointed, whether regularly or ad hoc basis, that has to be approved by you.
We have not given any approval because they have not given any. They have not actually enclosed the approval letter also. We have not given approval to any of the teacher as of now.
Okay.
My lord, if I draw my lord's attention to the order of the Honorable Court in the earlier round of writ petition, which is filed by the private respondent, my lord, there also it is a clear mention in the order, my lord. 4 sanction posts are being held. This is a submission of the government advocate in that writ petition itself, my lord, and that is taken into account.
Were you parties in that?
No, they were not a party in that case.
We were not a party, my lord. Managing committee was a party, but this is an admitted fact.
4 sanction posts may be there, but we are talking about the incumbents.
Yes, yes.
My lord, what had happened? We are the 4 founder teachers. So initially, when the school was founded, naturally we were not getting the grant. The school was founded in 97. Grant started from 2000. From 2000 onwards, we are getting the salary grant. 4 sanctioned teachers, we are getting the salary grant, and it continues till today, my lord, without any dispute. There's never a dispute raised by the government, my lord, saying that we are not. And in fact, my lord, our names are included. I have made a categorical statement, my lord, where we are, my lord, if I draw my lord's attention to page 10, my lord, of my writ petition.
Any statement made in the writ petition has to be supported by documents, Your Lordship. But in this case, it has not been supported by any documents, Your Lordship. So that is, let them show the document.
The government is already giving us salary grant. It is not, since 2000 we are getting, my lord. This school is being run by us from since year 2000 we are getting 4 teachers. We are getting. Till today it continues. My lord, if I am allowed to take, my lord, to para 4, my lord.
Yes.
That the petitioners herein are the founding members of the said popular government aid UP school Gandhi Mari, and has worked very hard to run the said school since its inception in the year 1997. Subsequently, in the year 2000, the aforesaid school started receiving government grant in the form of grant in aid to the tune of 6,000 per month in the initial years. At present, the school is getting, my lord, this is during the filing of the writ petition, the school is getting a grant of rupees 66,000 per month. That is, annually it comes to, my lord, 7,92,000 per month. Again, as per the normal procedure, the sanctioned teachers are supposed to get the salary as per the government notification sanctions issued from time to time by the Education Department, Government of Meghalaya, the latest of which was issued letter dated 29/6/2017, whereby it was notified that there was a payment of area enhancement grant in aid to 459 teachers under the ad hoc system at the rate of 9,000 to 18,000 for head teacher and 8,000 to 16,000 for assistant teachers, and the same is being followed till date. Now the next line, my lord, is very important. The petitioners herein fall within the list of 459 teachers. They are already included in the list, being the sanctioned teachers of the said popular government aid UP school, Gandhimari.
Where is this list?
My lord, this list of course is not been included, my lord, but this is a fact. If required, we can, my lord, get the list. But this will be, quite.
The fact remains, Mr. Abraham, the fact remains that all along, see the grant aid that was given to the school, from there it was disbursed to the petitioners.
Yes.
Whether they are regularized or whether they are ad hoc, in whatever capacity they are functioning, they are still getting that. There's no, as far as that is concerned, there's no issue.
There's no issue.
If you dispute that because they are not regularized, so they should not get that grant in it, then it's up to you to stop the payment. But you have not done so.
Yeah, what happened that we sanctioned the lump sum amount to the managing committee. Then the managing committee, they are managing to disburse the e-transfer the salary to their respective teachers. So we do not know the dynamic working of the managing committee, but whether they have been regularized or not, because that will open a Pandrabab, because we have not given approval, your lordship. So for that reason, I can also take instruction who are the sanctioned teachers, whether those all those 4 teachers they have been regularized or not. On that part, I can take a specific instruction.
So that becomes an issue now.
My lord will kindly see.
So now, because now what happened is this
honorable
there
court,
might be some other teacher also, because the teacher have been appointed by the managing committee. These 4 teachers, they have come to this court.
There are no other teachers.
Because those other teachers have been appointed by the managing committee. Whether any other teacher have been appointed by the managing committee, and whether they are getting the regular salary or not, those affect. Now if this court passes a special direction to release the salary to all these 4 teachers, then other teachers who are appointed by the managing committee also will face the consequences by this order. So for that reason, if I may be allowed to take instruction whether who are the sanctioned teachers and whether those sanctioned teachers are regularized or not, only that specific part of logic.
My lord will kindly see. My lord, this can be further clarified, my lord. We have given a representation to the government. Now that representation, my lord, is at page 54, annexure 6 of my writ petition, my lord. This dispute is being unnecessarily risen, my lord. But anyway, nevertheless, my lord, if I am allowed to read my representation.
Yes.
This was addressed to the director, my lord. I am the headmaster and of the aforesaid popular GA UP school, Gandhimari, West Garo Hills district. The said school was founded in the year 1997 by 5 teachers, including me, members, and the same received recognition from the office of the Deputy Inspector Schools, Dadengiri, Government of Meghalaya, wide order number. We have stated an order, my lord, number DISD so and so, dated 19/1/2000. And thereafter the said school started receiving ad hoc grant in aid from the month of March 2000. The said school was functioning as usual, and the last managing committee of the said school was formed wide so and so, dated 29/3/2018, which expired in 2019, my lord. During the subsistence of the aforesaid committee, I, being the headmaster of the school, was therefore the convener ex officio member of the said committee, and I was holding the post of draw and disbursement officer of the said school. During my tenure as DDO, there were no anomalies in the disbursement of salaries. The strength of the, here I have clearly stated, my lord, what is the strength? The strength of the teaching staff of the said school comprises of the following. So number one is petitioner number one, my lord. So these are the four petitioners before this honorable court. 1, 2, 3, 4. Fifth teacher is, my lord, Shri Noor Hussain, who is the assistant teacher. Here it's clearly given, my lord, non-sanctioned teacher. Sixth is, my lord, Abdul Samad Sheikh, who is the private respondent, my lord. Assistant teacher. This is the strength. There is no other teacher, my lord. This is a categorical statement, my lord. And it's not a case, my lord, that every time a managing committee has come, teachers have changed. In all these years, these are the very teachers who are serving the school. It is not a case that this year this teacher is appointed, that year that teacher is appointed. It's absolutely wrong. Even from the record, if it is verified, it will be seen that these are the very teachers. If I am allowed to further read the, my lord, my representation, my lord. However, in the year 2017, the aforesaid non-sanctioned teacher, Sri Muhammad Abdul Samad Sheikh, had filed a writ petition. I have very clearly stated, my lord, by WPC so and so 2017 in the Honorable High Court of Meghalaya, alleging that he is entitled to a salary of rupees 16,000, which is absolutely false and baseless. The said contention of the petitioner was refuted by the then managing committee and the state. My lord, state had already taken a very clear stand. It was made clear that Shri Muhammad Abdul Samad Sheikh was a non-sanctioned teacher, and hence he was not entitled to such claim. And further, the only claim was entitled to was the salary of 9,020, as was fixed by the resolution of the said aforesaid managing committee. The Honorable High Court was pleased to dispose the writ petition by order dated 1/8/2019 with the direction that the salary to be paid to Muhammad Abdul Samad Sheikh as fixed by the managing committee by its various resolutions amounting to rupees 9,020. Thereafter, several efforts were made by the said managing committee to disburse the salary to Shri Muhammad Abdul Samad Sheikh, but the same was never accepted by him. Again, to my utter shock, an ad hoc committee of popular GAUP school Gandhimari was illegally formed by the non-sanctioned teacher Muhammad Abdul Samad Sheikh behind my back. Needless to say that I, being the headmaster of the aforesaid popular GAUP school, was maliciously kept out, and the ad hoc committee had functioned with effect from 10/10/2019 to 10/1/2020, with a list of members who were neither the guardians or the or the students, nor had anything to do with the school. So, my lord, there was another writ petition which was pending, but subsequently it was withdrawn because by the flux of time, my lord, because that had become infructuous. So, my lord, the position is very clear. This is the strength of the school. He is the junior most. He is the junior most. And we are the four senior most teachers. We are drawing the sanction. And, my lord, even when the issue of drawing disbursement came, my lord, during the pendency of the writ petition, even the government has gladly given us that authority. It was never, that question was never raised, my lord, that whether they are sanctioned teachers or not. Government had readily given, my lord. It is an accepted fact, admitted fact. Can the stands be taken, changed at this point, my lord? Whereas even in the earlier round of litigation, where the private respondent has approached this honorable court, there also it is a categorical finding. 4 sanctioned teachers are there. That list I have shown in my representation. We are the 4 sanctioned teachers, other 2 teachers. There is no other teacher. In all these years, there is no other teacher serving in the school. It is not a case that every time a managing committee came and someone else became headmaster or head teacher. So it's a clear and short case, madam. We are the sanctioned teachers. It is also reflected in the earlier order of this honorable court.
But these records have to be with.
And my lord, if any dispute, now whether state can raise this dispute, my lord, if there is any dispute with regard to our sanction or not sanction, the private respondent should have approached this honorable court. It is, he could have said, no, this is incorrect, I am the sanctioned teacher. Or
So is there anything in your pleadings, in your counter affidavit, challenging the local standard?
no, my lord.
That I have not taken ground, because in my affidavit,
That ground was not taken.
we have already address the grievances of the petitioner
Exactly,
to draw the salary till up to June 2022. So that part, this matter become infractuous till that part. Then that I'm fine. But if any direction to be given, that is not a prior of the writ petition in this. That is not a prior of the writ petitioner in the writ petition. So that for that reason, I'm just agitating, rebutting the statement made by the petitioner because I have complained as part the prior of the writ petitioner. Till that, I'm fine. Then that matter become infractuous, that part. Then with regard to the private respondent, although these are the disputed question of fact, your lordship may travel and give direction, that is up to your lordship. I'm not onto that. With regard to the managing committee, I'm not to that. But only for further direction, that I'm aggrieved.
But how is he aggrieved? I don't understand.
I have
if it is as per norms.
Let him make submission then, so that he'll not interrupt me again, your lordship.
Okay, my lord. As far as salary grant, because that is also my prayer, my lord. Now, even let's assume a situation, my lord, where the procedure says that it should go to the managing committee. In absence of managing committee, draw and disbursement authority. Fine, if that is the norm, then okay. If that is the norm, then okay. But if there is any possibility or a notification that the salary can be given directly to the account of the incumbents, my lord, of the teachers, I don't think my friend can have an objection with that.
See, that would be incumbent only upon the managing committee as to whom the salary is to be disbursed to. So there's no managing committee now.
As of now, there is no managing committee, my lord.
Petition number 1 is holding the fort.
Yes.
As did you. So now he practically acts as the managing committee.
Yes, madam.
And
He's only the draw and disbursement power he is having,
no,
madam.
but even then, what happened is the grant date will be handed over to the petition amount, and from that amount of 66,000 he will disburse the salary to the other teachers. It should be to all the. Is it only to the 4 or to all the 6?
My lord, actually, my lord, what should legally happen, my lord? What is the legal position? There is a clear government instruction, my lord, that whatever is the sanctioned amount for the teachers, the managing committee has the responsibility to disburse the exact amount.
Yes.
There cannot be any adjustment. That is also admitted by my learned friend in the earlier round of litigation.
That
My lord.
we are clear.
So, my lord, that is the position. Now, what the managing committee was doing was that from the sanctioned amount, which is due to the teacher, suppose I am entitled to 18,000. So, what the managing committee is doing is that perhaps the managing committee is giving me 15,000. 3,000 it is taking away to disburse the salary of the other teachers. But the factual and the correct legal position would be, my lord, that whatever is my sanctioned amount, because there is a clear instruction of the government, that I am entitled. It is the managing committee for additional teachers. The responsibility is actually with the managing committee to disburse the salary, because they are the school appointees. But what had happened in the earlier occasion is that the managing committee was getting the sanctioned grant. Out of that, we were the 4 teachers, we were not getting our actual salary. Out of our salary, some amount was being deducted to pay the salary of the other teachers, which in fact that is also incorrect, my lord. That should not happen.
But that is not your case here.
My lord, I have stated.
For the last 1 or 2 years, there was no managing committee. But we have issued a direction to constitute a managing committee on 3rd June 2022. Whether the managing committee had been newly constituted or not, that part I have no instruction. So I can obtain instruction whether the managing committee has been constituted or not. In most probability, by now they might have constituted a managing committee. If this matter may come up on the next week, then I can take a complete instruction now.
But my lord, that is okay. But my lord, will this affect the writ petition? I don't think it is affecting the writ petition or the functioning of the committee also. But if managing committee is constituted, automatically the draw and disbursement will go to the committee, my lord.
And they will be the right person to say yes, Lord. So, if this matter
but there is no other authority disputing it, my lord. Now, whether it would be okay for my friend to raise this dispute.
My friend may not be so apprehensive. If there's not going to be any dispute, then there should not be too apprehensive.
No, so far there is no dispute, but whether state should raise this issue,
because This is school.
State is
this
for
school
whom, my lord?
managing committee, Your Lordship.
Is
So
the-
the school managing committee will be the best person to say if the managing committee has been constituted. For all this, for the last 2 years, we were taking the charge of the managing committee because managing committee has been the term expired. So there was no managing committee. So as of now, whether the managing
Whether
committee
whether you have appointed somebody to be in charge as a managing committee.
there was
More often than not, in such cases, an officer of the department is
We-
usually made.
we have taken charge, yes, Your Lordship, because we have constituted a managing committee on a temporary basis. That was for 3 months. That also expired. Then we have given direction to the senior most teacher
lord,
to constitute a
that-
managing committee. Then that managing committee was not constituted. So for that reason, we have given direction to the senior most teacher to constitute a managing committee in the year 2022, June. Now already 1 year. By now, in most probability, the managing committee might have been constituted. So
Lord, but
if
how-
if that be the case, then I'll take instruction whether the managing committee has been
That
constituted
would
or
be
not.
that would be
But
for
how-
for the future.
Exactly, my lord. How is this
management.
affecting the case?
But they will be the best person to say also about with regard to this salary,
No,
disbursement, all
but
these
my lord,
things.
what will be the? How is it going to help the case, my lord? It is regarding direction from this honorable.
Well, now they are talking about a misembezzlement of fund.
No, that is over, my lord.
Misembezzlement of fund by the private respondent. That
Why is-
part, you see, because
why is
that
my-
that part is that all these are remaining mystery because they are not even supported by any document when the money is been sanctioned.
The
when
fact,
the money,
see, the fact remains that the private respondent herein is not present for the court.
yes, sir.
Yes.
He most of the grievance is addressed against his action or inaction, whatever the case may be. And firstly, with regard to the so-called embezzlement or fraud, whatever the case may be, as far as the salary is concerned, for which he has failed to disburse the whatever is due to the petitioners. That part, like you said, some has been satisfied by the government and some have not been satisfied because it was embezzled by the respondent 7.
Private respondent.
Private respondent. So a direction to be given to him to refund.
Exactly, my lord.
So that is one thing. Now, as far as the future course of action is concerned, it is a prayer of the petitioner that the government may be directed to disburse to them through their, personal bank account.
That
So if that procedure is not there or is there,
My lord,
that is
that
would
is
be
something he can find from the
that would be
government.
the lookout of the government, if that can be done. In that respect, you can then verify whether the petitioners are really entitled to such salary or not, whether they are sanctioned teachers, whether they are regularized, in the post or not. That is up to you. But as far as the present situation is concerned, you have not raised that that issue.
Yes, my lord.
If you have not raised it in your pleadings, then you cannot do it now.
Exactly, my lord.
Even the prayer cannot also, because there's no prayer in the writ petition also, not in subsequently to release the salary to the petitioner. So that with
My
that,
lord,
with
if
that part,
that is so,
that
my
part
lord,
becomes
I may be allowed,
infatuous.
my lord,
That-
I
that
may be
part
allowed
become-
to read the prayer, my lord.
No, this
If my
prayer-
friend is
yeah,
insisting,
regulate.
I may be allowed to read the prayer.
Read prayer number 6. Anyway, Mr. Abraham, as far as that is concerned, see, this court will leave it to the government to decide on it.
Yes, Your Lordship. Yes, only that part. Only
And as
that
far
part-
as only that is only as regard the stand of the government. But if you look at the prayer as has been submitted by the petitioners, it's all directed against the action of the respondent 7.
that respondent 7, I have not
So
intercepted.
you are not in control of
I am
what he
not in
does,
control,
what
and-
he's not doing.
And I don't have any right to come to defend of private respondent number 7, Your Lordship.
Exactly, my lord.
Or Mr. K.P. Bhattacharjee, correct. counsel for the petitioner, who has submitted that the petitioners herein are the founding members of the Popular Government Aid, aided or aid?
This is
ad hoc.
What is the
because
full?
they are reading ad hoc grant, my lord.
What is the full form of the school?
School full form, my lord.
Is it Popular
My lord,
Government?
Popular Government Aid UP School.
Gandhinagar.
UP means upper primary, my lord. UP School, Gandhimari.
School, Gandhimari, West Garo Hills.
My lord, this will be West Garo Hills, my lord.
West Garo Hills,
This comes under Fulwari, my lord.
which was founded in the year 1977.
1997, my lord.
Oh, sorry, 1997. Subsequently, in the year 2000, the school started receiving grant in aid from the government, initially for an amount of rupees 72,000 per annum, and as on and at the time of filing of this petition, an amount of rupees 7,92,000 per annum was disbursed to the school regularly. The said grant in aid is supposed to be is supposed to form part of the salary of the teacher. Not only salary, this is also given to the salary of the staff, isn't it?
No, my lord. Only for
Purely for salary.
Purely salary, my lord. Ad hoc grant.
Salary of the said teachers, of the teacher of the school, which includes the petitioners herein. Next. The Land Council for the petitioner has further submitted that in due course, one of the junior most teacher, MD1, the junior most teacher, who is the
In fact, who is
private
the
respondent,
sixth teacher, my lord?
junior most teacher out of a total of 6 teachers of the said school, that is the respondent number 7 herein, had taken over himself the power to draw and disburse salary,
He had formed an ad hoc committee also, my lord.
for which he had formed an ad hoc committee, managing committee, for this purpose.
Behind the back of the petition.
So this DDO power was also approved by the government.
Yes, my lord. This was from behind the back of the petition, my lord.
Which was duly approved by the government. Such action being done without the knowledge of the petitioners hearing. On the strength of such power as DDO, drawing and disbursement officer, DDO, the respondent number 7 has been drawing the said grant in aid but has failed to disburse the said salary due and payable to the petitioners. From which date?
My lord, this was with effect from So this was with effect from 1/9/2019 to 28/2/2021, my lord.
With effect from 1/9/2019
Yes, my lord.
to
To 28/2/2021.
2022, 20,
2021, my lord.
2021.
In a very detailed way, my lord, I have shown the table also,
Yes.
which is there at page 12 and 13 of my writ petition, my lord.
It is also the submission of the learned counsel that a detailed breakup of what is due and payable to the petitioners has been part of paragraph 4. Is found at paragraph 4, at paragraph 4 of this petition. Reference being made to the table A and table B therein at page 12 and 13 respectively of this petition. In course of the in the meantime, while this petition is pending before this court, certain developments have taken place, in as much as the petitioner number 1 was he was headmaster since inception. Who was the headmaster? Who is the headmaster of the said school?
He was not the headmaster that time, he was the senior-most teacher.
Head teacher, my lord. That is how it is.
He was not the head. He was
Head teacher
downgraded because by the ad hoc committee he has been downgraded.
My lord, that is what I am saying. This fact was also challenged before this honorable court.
That time when
But my lord, that matter has become infructuous with influx of time, because that order has been replaced.
So we'll put it that he was also not designated as head teacher.
His in fact correct position, my lord, is he is the head teacher. Just because a junior most teacher by misleading takes that position, is he entitled to do that?
Whatever the case may be,
Yes.
we'll not go into it because that
Yes,
is a subject
that is
matter of a
his,
different thing. What we say is he would be considered. Are you disputing the fact that he's a senior most?
How can he dispute, my lord?
he is the senior most, but not the headmaster at that 11
Let's
point.
put it at
My lord,
this.
senior most is head teacher.
Hakasaka headmaster to I know senior most teacher. No?
Yeah, he's the headmaster.
Then it may be stated as head teacher, my lord.
Cannot be because
Head teacher is a designation, isn't it?
senior most teacher because as
My
per
lord,
my
senior most
My
teacher
lord,
is
my
by
lord,
virtue of his-
as head teacher, he is also having additional grant. His salary, as per government sanction, is 18,000, my lord.
as
Other assistant teachers, which he is
yeah,
getting,
that has been.
which he is getting, my lord. Other teachers are getting 16,000. He is getting that amount, my lord.
So now he's getting 18.
Yes, that is as per the last sanction. If there is any change thereafter, I don't know. But at the time of filing of the writ petition,
as per my affidavit annexure 1 at page 7, I have stated that senior most teacher.
so my lord, thereafter who is there? If he is the senior most, then let's assume a situation, my lord, he is the senior most. Then who is the head teacher?
But this senior most and headmaster, but that time he has
So
been
my lord-
downgraded. Although he was not headmaster, no longer headmaster.
My
but still
friend
then he
is-
is the senior most. So I have stated that senior most teacher in my letter.
My lord, my friend is as if he is arguing for the private respondent, my lord.
But I'm going by my
No, he's
affidavit.
trying to keep the matter in perspective.
My lord, because that cannot be allowed. That cannot be taken into consider because that itself is illegal, my lord. That is exactly why that was challenged before this honorable court. It's a different fact that
Okay.
since it had become infractious,
Let's
it
put
was
it
over,
this,
my lord.
let's put it this way. It line to who is allegedly the head teacher has been given the power of drawing and disbursement
Yes.
officer.
Yes.
Where is the reference to that?
That is in my affidavit, page 7, Annex 1. My affidavit filed by respondent number 6, Your Lordship. Affidavit filed by respondent number 6.
Annexure?
Annexure plus Annexure 1, page 7. Annexure 1, page 7, Your Lordship.
Here you say senior most teacher.
Yes, senior most teacher, yes.
Kunum to that? Drawing disbursement officer. But this does not say that he has been given the power of DDO. It is here. It says that he is only allowed to draw the pending salaries.
Yes, Your Lordship.
Till June.
Till June 2022, yes, Your Lordship.
That does not make him the DDO.
No.
DDO would be for a certain period.
Yes, Your Lordship.
But here is only specifically meant for the pending salary.
Yes, Your Lordship.
This, but he actually should have mentioned. I don't know why this was not mentioned. I'm also seeing it for the first time. This is something that he should have mentioned.
Who should have mentioned?
My lord, the SDSA, my lord. That should have been a part of the order.
But it has not been mentioned here. But you claim to be the DDO.
My lord, now it is being
on the basis
disbursed to
of
the-
this.
Yes, my lord. He should have categorically stated. I don't know why he's
managing committee has been the point. No, that's why I was just that I leave it to the Lordship. Your Lordship.
my lord. Managing committee direction can be there from this honorable
Yeah,
court if it is not constituted.
Pomleti bentapi puli biang tu
My lord, he's also admitted as that convener. I am the convener. Come ex officio
we'll go
member.
by this notification, by this communication. Pomleti allegedly Rumo, who is said to be the senior most teacher, was given the power to draw the pending salaries of the teachers till June 2022.
My lord, if kindly excuses me for a moment, my lord. The nature's call.
Oh yes. Can I go ahead with the dictation or should I wait for you?
It's okay, my lord. I'll be there in a minute.
You are there also in this case?
No, my lord, thus I am helping.
Oh. I thought you are there. Kunu to go? This is evident from the communication. Number, can you speak in annex to one more? Issued by the SDEO, Subdivisional School Education Officer, Darengiri, to the Branch Manager, SBI, Chibinang Branch, West Garo Hills. See, Mr. Abraham, your letter is not very clear. You have written a letter to the branch manager with regard to the power of DDO. What is the point of writing to the branch manager to say that the convener, ex-officio member, is directed to convene general meeting of parents and guardian to reconstitute the
That part should not have been included, but since this is the letter communication by the district school education
What has the
officer,
branch
so
manager got to do with this?
that's exactly, yes, Lordship. That part should not have been included in this
You
letter.
should have. Okay. You have given a copy to the petitioner,
Yes, madam.
but it doesn't mean that it's directed to him.
That's what I think maybe that part should not have been included in. The second part should not have been included in this letter. Also.
Well,
Yes,
this
Lordship.
letter itself is defective actually, but nevertheless, madam.
It's defective in all
Yes.
respect.
You
Firstly,
should have given it, addressed it to the petitioner.
you have addressed it to petitioner. Maybe copy to.
Copy that they have
Even
given
if
to
you
the-
have given to
they have given
branch
copy
manager,
to-
fine, but it should be specific.
Yes, it should be specific. This
What
letter
has
should be.
what has the branch manager got to do with your constitution of the managing committee?
Yes, I agree with you.
Anyway,
Lordship. The second para should be separate. In the letter, it should be yes.
So till date you are functioning as DDO.
Yes, my lord.
The
My
petitioner,
lord, it is stated in the affidavit, my lord.
the petitioner number 1 is accordingly functioning as the DDO till date.
My lord, if I may
till
take my lord
date-
to the affidavit, my lord.
Till date, Your Lordship, because
Para
that's a-
6.
That's what I was just a little confused. If managing committee is constituted,
Well, it's a natural thing.
That
my lord.
will look.
It is there in our prayer also.
Your
My lord will kindly see paragraph 6 of their affidavit, my lord. Paragraph 6, the sub-para, my lord.
yes.
However, it is pertinent to state herein that the respondent number 6, white letter dated so and so, had authorized Sri Mukul Hussain Bipari, senior most teacher of so and so, to draw pending salaries from the school account. The order supersedes all earlier orders. In the meantime, of course, there is a direction.
No, we were discussing this letter itself.
Of course, it is defective, my lord. But he is continuing.
Fine. It is also next. It's also the submission of the Learned Council that in the meantime the government has disbursed. Is it pending salary or what? What was
Pending
it?
salaries, and then if I remember, my lord, he said that present salaries also they are withdrawing, my lord, they are getting.
You said, you see, let us be clear. First, you said that in the meantime, the government has disbursed the area salaries to you.
Yes, my lord. From which is from, my lord, that is after, my lord, after 28 to 2021. That means it will be 1/3/2021 onwards, my lord. Because when we approach this honorable court, even the sanctioned amount from the from dated 1/3/2021 till 22, my lord, we did not receive.
Yes.
So therefore, this letter says that these pending areas which are there.
Okay. On the
Yes,
basis
sir.
of that.
Yes, my lord.
Has disbursed the said pending the set areas of salaries on the strength of the said communication dated
My lord, this is dated
3rd June.
3rd June 2022.
3rd June
2022.
2022. And further, till date, the present salary of the teachers was also disbursed by the petitioner number 1. Next, to this extent, the Legal Counsel for the petitioners has submitted that no grievance remain. However, what remains is the fact that the private respondent number 7 has yet to release or rather to refund whatever is due and payable to the petitioners as far as their salaries are concerned, with effect from 1/9/2019
yes.
to 28/2/2021. And in this regard, it is prayed that the said respondent number 7 be directed to refund or pay the said amount due and payable to the petitioner's area. Another prayer made by the petitioners is that the government may be directed to deposit the salary of the teachers out of the set allotted fund directly to their respective bank account. Mr. H. Abraham, learned GA, appearing for the state respondent, has agreed with the learned counsel for the petitioner as far as the action of the government is concerned, to the extent that the petitioner number 1 has been given temporary charge as DDO to clear the said pending dues by the said notification communication dated 3/6/2022. It is also concurred that the government has in the meantime cleared all the pending dues till all the pending dues, and the present salary has also been disbursed regularly. Therefore, as far as the government is concerned, the petitioners would no longer have any grievance against the same. Those are the only two things that you have done.
Only one small submission, my lord. Because now, having gone through the letter, my lord, if, my lord, the authority issues a specific letter, my lord, stating that I am the draw and disbursement, although it is admitted, because then this letter is it's a little vague, my lord. If a specific order is issued that I am the draw and disbursement officer till the time managing committee comes into existence, my lord.
So admittedly, there is no managing committee.
My lord, this is there in my prayer also, my lord. So it's not a case that I have not prayed.
Yeah.
My lord will kindly see at prayer 8 Gray rate is that managing committee should be constituted.
That's what I was just telling. I was making my submission, Your Lordship. This notification was issued on 3rd June 2022 to constitute the managing committee. It is more than 1 year. So whether the managing committee has been constituted or not is not within my knowledge.
No, my lord,
So
if that order,
perhaps managing committee by now would have been constituted.
even assuming, my lord, if managing committee is constituted, automatically it will go back to the committee. Now, my lord, that is why if the order says,
Yes.
my lord, if the order says,
But now, by chance, if managing committee is constituted, then they'll interpret
it is not constituted, my lord.
then they'll misinterpret it. I have been
no.
given the power
No,
of
it's
a joint disbursement officer.
to my
That would
knowledge, my lord.
misinterpret, Your Lordship.
It has been stated at the bar that the managing committee has not been constituted.
Not been constituted, to my knowledge, my lord.
So,
No,
that-
I have no instruction that.
My lord, I have instruction.
yes, that's what he has. I said it has been submitted at the bar.
Yes.
So the court will go by that to say that the managing committee has
It's not
yet been
constituted, my lord.
because the fact remains that your communication is defective in any case.
Yes.
It was not directly addressed to the petitioner.
Yes, my lord.
Petitioner number one to to
As a joint disbursement.
to confer upon him the
Joint disbursement.
the power of convener.
Convener power is
You
given, my
say
lord.
you convene a meeting, but
Yes,
it was addressed to the branch manager.
I fully agree with Your Lordship. You said.
So we will rectify that situation as Mr. Bhattacharjee has submitted. We will rectify the situation and direct the government to reissue fresh direction to the petitioner number one to constitute the or take step for constitution of the managing committee.
My lord. And till then, my lord, if
Till then, of course, that power
joint
will-
disbursement.
so that will not disturb the.
That will only by accident if the managing committee was constituted. That is the only.
when he
update.
says so,
if managing committee is constituted, government will receive
yes, you have not
letter
received
for
any-
resolution that kindly approve our managing committee.
This letter, this affidavit, I filed it in the 2000. I filed.
Which is issued to the branch manager or not.
I filed in the June 2022. So I have no
My
communication.
lord, I have
with the
clarified that
authorities.
fact, my lord. Managing committee is not in existence. And this direction is issued to the state bank manager, my lord.
Managing committee.
So you do that.
I have no instruction whether the managing committee has been constituted or not. That part at least because so that.
That's what he said. He said it has
My
not
lord,
been.
my submission can be recorded.
That's what I said. See, when the court says statement at the bar, so that has to be taken to. If not, if it is otherwise, then the council would be held, for perjury.
That part is.
This court has considered the submission made by the parties and has also noted that the respondent number 7, though initially had entered appearance and
No, my lord, he never entered.
or never entered, the respondent
It went
number
ex
7
parte, my lord.
has failed to enter appearance in this proceedings. For which, is there any specific order?
Yes, my lord. Specific order.
Where is the order?
My lord, this may be sometime in the month of. My lord, it should be sometime in the month of May or June,
Yes.
my lord, 2022.
This is Kunung Toko. For which this court by order dated 10/6/2022 has directed that he may be proceeded, that the respondent 7 may be proceeded ex parte. As far as the next one. As far as the submission made by the learned counsel for the petitioner relating to the prayer made in this petition, which have since been complied with, nothing remains to be decided upon. However, as regard the prayer to direct the respondent number 7 to refund the money drawn in excess or allegedly misused by him, which corresponds to the aforesaid table indicated above, the respondent number 7 is hereby directed to refund such amount. For which the petitioner is at liberty to take necessary steps in this regard. So that deals with the refund.
Or the respondent.
Now, as far as the prayer made for disbursement of the salary directly to the account, bank account of the petitioners herein, this according to this court, this is a procedural matter which should be decided by the government in accordance with the norms applied in this regard. The petitioners are at liberty to approach the government for this. In course of hearing, the learned GA has raised a pertinent point, questioning the petitioners as to whether the managing committee was directed by the communication dated 3/6/2022 was constituted, to which the learned counsel for the petitioner has stated at the bar that such,
to my knowledge,
stated at the bar that as far as his knowledge is concerned, the said managing committee has not been constituted. Be that as it may, next, the government is directed to issue fresh direction in this regard as far as the constitution of the managing committee is concerned, which, as and when it is constituted, will take charge of the affairs of these.
Malam.
Anything else? In view thereof, this petition is only disposed of. No cost.
Oh, my lord, that fact, my lord, till the managing committee is comes into existence, my lord, at least the order should be clear, my lord, as far as the draw and disbursement.
Till the managing committee is constituted, the power, the petition number 1 is to continue as the DDO in terms of the communication dated 3/6/2022 supra.
Item number 15.
Right to. Please, Your Lordship. Your Lordship, I crave Your Lordship indulgence. Lordship, in this matter, it has come from Honorable Justice here. At that point of time, I was not appearing before this court. Now it's come before this court, so I've just not gone through the brief also.
You are appearing for
Private respondent number
private
4.
respondent. We will give him chance.
Yes, 2 weeks, I'll be ready.
But further time may not be granted, my lord. Yes, it can be.
Mr. P. Nobri, London Council for the respondent.
4.
Respondent number 4.
Private respondent number 4.
Submitted that he has just taken over the brief recently and would require some time to prepare for this matter. Accordingly, a conversation is sought for the day. The same not be objected to by the petitioner. Allowed. As prayed for, this is matter after 2 weeks.
Yes. Must.
Item number 17.
Yes, tell me.
Your Lordship, as per last order, we have taken steps, Your Lordship, with regard to the respondent 3 and 4. So the report is still awaited, Your Lordship.
Who are respondent 3 and 4? Yeah, the complainant.
They are private respondents. Complainant, Your Lordship.
Complainant before the local
One is one is respondent 4. It's a complainant
Human rights.
before the human rights, and then the respondent 3 is the one who filed the FIR, Your Lordship, for the.
So we'll have to wait.
Respondent 3 is the complainant and 4 is the victim.
For 3 years.
So we'll wait for the report then.
Lordship.
Then the counsel for the petitioner submitted that the notice issued upon the respondent 3 and 4 respectively has not yet been received as to whether the same has been affected or not. This being the case, it is submitted that the service report be awaited. Accordingly, this is matter after 1 week.
With 2 weeks, Lordship.
They are local.
Yes,
Lordship.
yes, sir.
Then Shillong.
One from Nongpo and the other one from Shillong.
Even Nongpo. You have taken steps.
Yes, Lordship.
So perhaps by this date, 2 weeks must have passed.
Lordship. It
1
came
week
up
or
on
2 weeks?
31st.
Okay. So if you go another 1 week, should have been. These matters should be disposed of.
In fact, Lordship, it's fixed for hearing since August 2022.
But now, since all the parties have to be given the chance to appear, so this is matter after 1 week.
Yes, Lordship.
Gini, buat lah tu kayu.